All right, on to the final module, module number 6 on ethics and dispute resolution. So just like the last module, I'm going to keep it kind of light because we still have your team projects with the scope writing that still has to take place and get completed. So this one just has a couple chapters to read, chapter 7 and chapter 20, dealing with disputes and dispute resolution. And then no assignments. You also have to read chapter 21 on ethics, but then we'll have, more of the ethics discussion will be in the actual discussion post for this module. So that discussion post is based on, again, one of the AGC case studies for different issues that come up on projects. And again, those are, real issues. So I like going through those and making sure you guys have a good understanding of the different challenges you might face. So that discussion post will take place just as it normally would, and then you'll have a quiz on disputes and ethics, and that information will come from the chapters. So when it comes to disputes and the lecture material, again, you guys can read through most of the stuff, but generally speaking, when it comes to disputes, we're not dealing with a lot of legislative law. We're not dealing with any constitutional law normally or equity law. We're normally dealing with changes that take place on a project. We're dealing with differing site conditions. We're dealing with delays. We're dealing with payments and back charges. For those of you who might not be familiar with back charges, those take place quite often when, say, for instance, one subcontractor might damage something of another's, and they want to charge that person, or if a subcontractor is delayed by something, they want to be paid back for any damages for delay. That process can get pretty hairy, and it's something that, as you learn the management process over the years of experience that you gain, the better you are at pre-construction actions, writing scopes, adding back charges in the process for that, adding, how to deal with disputes, and going through all that kind of stuff before you award contracts, like during the bidding phases, during you know, post-bid meetings, pre-bid meetings, all that kind of stuff to kind of lay things out and have the document signed, basically saying, "Yep, I understand that that's the process, and if I don't follow that process, I'm not going to be awarded back charges." That kind of helps set the tone, but also, even more importantly, building relationships with your subs and with the owner and the architect teams, so everyone's kind of on the same page, and that takes years. It doesn't just happen overnight, but that's where tying disputes in with ethics, holding yourself accountable for issues, not just fighting to be right all the time, because there's such a huge matter of perspective in every single situation that comes up, that it's really important to understand that, we have the contracts and the legal documents to back us up, but in reality, what we're really working at is building levels of trust and being reasonable, right? So that's why we use those words, and going back to earlier chapters talking about reasonable and promptly and intent and all that kind of stuff, because when you have a good moral compass and you can follow a good baseline of ethics, that helps build much better levels of trust within the team, that then you hopefully don't have to deal with so much of this stuff because you can all be reasonable with it. So these are where you see most of your issues, with these items listed here. And having those standard contracts are really what helps us sort of set that baseline for setting a precedence on how we handle things moving forward. A couple other important terms, right? We talked about intent before, same thing with reasonable, right? These things kind of come back in, and they're hard to interpret, but they come back in disputes because it's easy to say it was my intention to do something, but then you have to back that up, right? So we have different things called substance and form, right? So we have substance, which is inferring an inference based on actions, and you have form, which is actual written verbiage into documentation. So both those things come into play when it comes into intent, when you're trying to interpret different scenarios. So again, just with everything else within this entire class, we're dealing with risk constantly. We're dealing with understanding interpretation of documents. We're learning what all of our limitations are, what our barriers are, and figuring out ways that we can minimize our risk and make decisions that help the project as a whole, not just my company versus your company versus everyone else. Because at the end of the day, the project is the project and needs everybody to pull their weight and do the right thing for the project. And that's the best way that you can set up success for the entire project team. So sometimes you have to give in order to have you know, a much better end result. But it has to be reasonable. Make sure that you're going through, making sure you're going through the process and doing things the right way for the project team. Exculpatory provisions are important to understand too, because these are provisions within your document that kind of shift liability in a way that you might seem as unfair. So a couple of the examples like this, I guess the definition is one party. Typically, the contractor is asked to assume liability that would not otherwise be assumed, right? So a lot of times what might happen is something like subsurface conditions. I've seen that quite a bit where, owner is not going to hold themselves responsible, or the architect will hold themselves responsible for subsurface conditions. That's going to be shifted to the contractor. Same thing with like design liability for different pieces of it. So some of those things those are just examples I've run into kind of regularly, I'd say. Um, Sometimes it might be valid though, just because the owner in their argument all the time is, well, we're hiring you, the contractor, to do all these things for us, and like we wouldn't know any different, so you guys should know better. So again, there's sort of that intention and what's reasonable, right? So there's such a wide range of gray area that you just have to understand at least what an exculpatory provision is, why it's important, and how to sort of, I guess, look out for them. A tort is a very common type of dispute issue within construction. Basically, some sort of civil wrong committed that causes loss or harm. Some very common types of torts are trespassing is one that's really is common, right? So if you're dealing with a project that, like a campus, for instance, a lot of times you might have students that don't want to go around your construction fence. They want to go through it because it's the quickest way to their projects. Not to say I haven't seen that before, but we also might have issues where, again, I've had people pull up their cars close to the project site and that have scratches on them and say, "You guys scratched my car," so they're going after torts for things like that are causing damage to property, stuff like that. Probably the most common when it comes to actual construction though is if, and this leads or ties back to back charges, but if a subcontractor damages someone else's stuff, right, that's technically a tort. You're causing damage, you're causing loss, potentially harm, right? So then if you get into a situation where you're acting unsafely and you're potentially causing harm to someone else, that's another example of a tort. So, normally those things are minor and they are resolved relatively quickly. Again, having a good discussion and a process for how to handle back charges is a really important process. So anyways, that's just kind of what Chapter 7 is about, just different types of disputes and what torts are. Getting into Chapter 20 is talking about dispute resolution. So a lot of different types of it. AIA documents have, their general sections that talk about it. Consensus docs do the same thing. Step one is always negotiation. Normally, it's extremely uncommon for a contractor to go to litigation just because everyone knows how much time is involved, how much cost is involved, and normally it's not worth it because you're talking relatively minor dollar values, right? So there's gonna be a lot of disputes on $5,000 to $10,000 to even $50,000 or $100,000. But if you start bringing those things to court, now the legal fees and all the processes are going to cost you way more than $100,000 no matter what. So negotiation is always the best step, right? That's where we always are. Normally there's a lot of trade-offs involved with this. There's a lot of, again, going back to being reasonable, dealing with things sort of promptly, making sure that in pre-construction before awarding subcontracts that we know that this is how we're going to deal with disputes so that you can't just bring things up at the end of the project because you realize that, hey, you looked at your books and you guys didn't make money like you thought you would, so we're going to figure out ways to try to back charge people to make up for the difference, right? So that kind of stuff might happen too. So if you have time limits set for your project on when disputes can be brought up on things like that, normally that helps alleviate a lot of the problems. Step two, obviously, then we'd have something like litigation. That's when everything else fails for the most part. a lot of different alternate dispute resolutions, partnering, mediation, arbitration, review boards, mini trials. I'm not going to go through most of the stuff because I'll let you read through it, but mediation, arbitration are a big deal because in your contract, um, arbitration is the primary means of dispute resolution. And what arbitration is basically in a third party who is agreed upon by both of the disputing parties comes in and they have, they have hold their own sort of hearing, and it's decided kind of by them how they want to do it. There's going to be some sort of testimony. There's going to be some actual legal process that goes through where you present documents, and then it's kind of up to them for how they want to cross-examine, if they want to have people sort of in the both parties in the room together, or if they want to do things separately. But whatever the arbiter comes up with as being sort of the resolution, that is a binding document. That's a binding resolution that both parties then have to agree to. The difference between arbitration and mediation is the mediator is, again, an agreed upon third party person where the fees are split. But the third party mediator has a little more freedom in how they want to handle the process. It's a little less of a specific structure. And the biggest difference is the mediator's decision is non-binding. It's a recommendation. So mediation takes place a lot quicker than arbitration because it's not as formal of a legal process. And you do not need to follow along with their final resolution. The issue I've seen, fortunately, I've never had to go through any of these processes before because everything is generally handled in that negotiation phase just between your company and whatever the other dispute company is. But what I've learned about and seen in the industry a lot is arbiters tend to sort of split the difference, and then you're stuck. And it's kind of the same thing with mediation, except for mediators, since it's non-binding, they might have a little bit better look at it. But the problem then you run into with mediation is the company who's on the showing to be on the losing end will say, I don't agree to that, so they go to arbitration anyways. So just a couple things to be aware of, but that's sort of the general idea of the process and how it works. So, right. So this is a very common, again, just going back to some of the other things, torts, right? Wrongful acts, a lot of damage, injuries on a job site, something like that. Scope inaccuracies are one of the bigger things, along with back charges and delays. So these are the things that we really have a lot of control on. Torts not as much, but a lot of that can come up with safety, and it can be tied back to scheduling, right? If you have the wrong people in the wrong places at the wrong times, then you might be overloading some parts of your project and just setting yourself up for failure, potential damage to property or whatever that might be, or injury, right? Because if you have unclean site and overcrowded site, injuries are more likely to happen. So the next three, though, the scope inaccuracies, the back charges, and the schedule delays are where you really see the primary issues, and it's not so straightforward, right? It's like a schedule delay is really hard to determine who's really at fault because every issue has multiple people that are involved. So, and again, just understanding the importance of documentation with dispute resolution, because because so much of our industry and so much of any job really is about verbal messaging. So if you, what I've always recommended to students and what I used to do is have a call log, so that every time I had a phone call with anybody, jot down a few notes of all the key points that were discussed, and then generally have some sort of quick follow up into writing with an email or into whatever our documentation is for our daily meetings or our weekly meetings, wherever that might be, just saying based on conversation with so and so on X date, it was decided that we were going to do this. Those are the little things that kind of help set the tone. Everyone understands that we're on the same page. That was what was discussed. Writing things down, having a good, clean, organized format for how you do that is a huge benefit to you in the long run, because you will have all the documentation ready to go, and it's really hard to argue with that, as opposed to a lot of people who decide to not document a lot of things, and they end up just trying to say, argue some of these disputes based on just he said, she said type deal, and that really never goes well. So I can't emphasize enough the importance of good, clear, concise documentation. It doesn't have to be paragraphs and paragraphs of things written all the time. Just writing quick notes with approvals and who we talk to and say, yep, we're good with that, good, and move on to the next thing. The quicker and more concisely we can do that, the better it is for everyone else. Another important thing to understand too is understanding minutes. Meeting minutes are a really big deal, and I've seen so many very poorly written meeting minutes that if you're not in that meeting, you have no idea what was actually taking place, who said what, who's responsible for what the next steps are, what the actions are, what are our goals for the next time we're meeting, or so that's kind of holding the minute taker liable, which is generally the contractor. So can't emphasize enough, taking good minutes, understanding who's agreeing to what the actions are, and how we're going to be moving through. Um, so again, just like anything else, the best methods of dispute resolution, the best methods of managing your project deal with getting ahead of them before the project starts. How are we going to do it? Set the precedence, then have a nice, clear, concise approach, build that level of trust with everybody, hold yourself accountable for the things that you're doing, and that helps everything in the long run. A couple other documents here to look through as well that are important. So Spearn Doctrine, and then other clauses that put you at risk within our contracts, and then what a flow down clause is too, because the flow down clause gets you. So the Spearn Doctrine is really good for helping protect contractor. Flow down clauses are easily to miss for subcontractors, especially because they're basically bound to whatever the contractor has with the owner. So it's not always very apparent what they're liable for all the time. So it's good to understand what a flow down clause is too. So, all right, well, I'm long-winded again, but I think that's about it for this chapter or for this module. And then you have your final exam coming up next, and I will not have a video for that. You just make sure to take your course eval, and then, oh, gotta hide some of this stuff for you. And then make sure you get your final exam done. If you have any questions, let me know. Thank you.